You would think that, I mean, you sign a contract to sell someone else's work as an agent, and I mean, you would think that she's supposed to sell my work and be my agent, which she hasn't done. And so, I mean, I assume that she's not following the contract. Why should I?
I mean, it's just typical distortions of job. The reason he's alive today is because he's been eating off of the money earned from the jobs that I set up for him.
Wait a minute.
These two people, John, a graphic artist, and Marie, his agent, have a contract. Now that contract is no longer working. Sometimes even the best of agreements go awry and need outside help to get them back on track. Most artists are absorbed in their work and find legal matters cumbersome and complicated. They often jump into projects deciding to work out the contractual details later. But differing expectations and assumptions about the work created can lead to disputes. Arguments can be very heated when the creative process is involved.
There are a lot of artists out there who don't understand the law, that don't understand the best way to go into things from the business perspective, don't understand some of the, just don't have the information at their disposal.
When a dispute develops, many people don't have the time or financial resources to use our complicated court system. They often need to identify their issues and concerns, rebuild working relationships, and arrive at new agreements.
It was getting to the point where I would just call up this person, or this company, we'll call them, and immediately I would start getting this rude response, which made me react, and then they would react to me reacting, and we would just end up yelling at each other and not getting anywhere.
When Gary Ortega needed help in resolving a dispute, he turned to the services of California Lawyers for the Arts.
So it was kind of nice that it was going to take a turn that neither one of us had to face each other, that one person would face each of these persons, a neutral person, an objective person, and then make a decision which we both agree whatever that decision is would be the final decision and go with it from there.
Mediation through arts arbitration and mediation services may be appropriate for the many kinds of disputes experienced by artists of all disciplines.
CLA was established in the early 1970s to act as a bridge between the arts and legal or business communities. In 1980, we formed the Arts Arbitration and Mediation Services as an alternative to litigation and to settle disputes between artists. Arbitration and mediation both involve the use of third-party neutrals to help resolve problems. In arbitration, a dispute is submitted to a third-party neutral for a decision, much like a court proceeding. In mediation, the third-party neutral acts to guide the disputing parties to come to their own resolution.
This program helps artists negotiate for themselves and work out business issues and conflicts that arise in normal business. Artists have special needs. Artists are also like other small business people. They are always negotiating contracts, working out agreements on the fly, hiring people. They have a whole range of business issues that sometimes result in disputes. And what we're offering them is an attentive, experienced, neutral person who helps each side come to the table and articulate what it is they thought they agreed to, what they want, how they see the other party's role in the relationship.
We're going to show you how John and Marie worked through their problems to reach an acceptable agreement. John begins the mediation process by calling Arts Arbitration and Mediation Services.
Hello, Arts Arbitration.
Hi, my name is John Sinclair. Is this California Lawyers for the Arts?
Yes, it is. Actually, you've reached Arts Arbitration and Mediation Services. We're a program of California Lawyers for the Arts.
Okay. My name is John Sinclair, and I'm a graphic artist in the city. And I'm having some problems with my agent, and I think I may need some legal services.
Okay, well, let me tell you, first of all, what kinds of services we provide. We not only have referrals to attorneys if you do...
Callers are told that Participation is voluntary. Nothing is done without the participants' consent. There is a low sliding scale fee. Meetings are held at neutral locations and all information is confidential. The mediators are impartial and participants formulate agreements with the mediator's help. The participants help shape the process at every stage.
And what's going to make that agreement any better than the agreement that we already have that she's not performing to?
Well, should she decide to come, you expect that there's good faith there, and the mediator helps you come up with something that you both feel you can live with. And at the end of the hearing, the mediator writes up points of agreement, and you both sign it. And you both take home hot copies. It's like a contract. And then if one of you decides that you can't live with that, either you can mediate it again, go to arbitration, or you can use the contract as evidence of a relationship between you if you ever had to go to court. Hopefully that wouldn't be necessary.
I see.
If a caller decides to try mediation, the staff contacts the other person involved in the situation. Upon their agreement, arrangements for mediation are finalized and appropriate mediators are selected.
First thing I do is review the staff report on the parties and their summary of what the dispute is about. If I feel I need more information, I'll call the staff intake person to discuss it with them. I sometimes give some thought to ways of resolving the dispute, but I try to restrain myself because I think generally it's better to let that evolve out of the process.
Mediation is a process, an art that encourages people to find their own solutions. The mediators themselves take special training to remain neutral while assisting others in making their own decisions. They're drawn from the arts, business, and legal fields.
It's not up to the mediator to resolve the dispute. It's up to the parties to do it, and the mediator is simply there to facilitate that.
So, would you be interested in me contacting this party?
Yeah, please.
Okay. And of course, I'll explain to her what I've told you, that it is confidential, and that's another point to really think about. That if you go to court, sometimes you don't always want everyone to know about your situation, and through this, nothing that you say to me or in the hearing can be said outside of the hearing. So, and I know that's a concern for a lot of people involved in disputes. So why don't you give me her name and address?
All right.
All participants are asked to sign a confidentiality agreement. This guarantees that only the final agreement can be used if there are any subsequent legal proceedings. This method of protecting all conversations and written information introduced during the mediation encourages an open discussion of all issues.
Okay, well, I'll wait for your letter. Thank you very much.
You're welcome. I'll talk to you again soon.
Bye-bye.
Bye-bye.
I want to thank you for coming to this hearing and choosing to mediate your dispute. My name is Oscar Goodman. I'm with the Center for Social Redesign. I've been trained as a volunteer mediator and arbitrator for California Lawyers for the Arts. I'm also on the American Arbitration Association commercial panel, and I'm a member of the Society for Professionals in Dispute Resolution. Judith?
I'm Judith Roberts. I'm a full-time business mediator. I have quite a bit of experience and training from California Lawyers for the Arts in mediating your type of disputes. Also a member...
After introducing themselves, the mediators describe the process so that everyone knows what to expect. Then they set forth two important ground rules: no interrupting and treat each other with respect.
In this procedure, what we do regularly is ask the first party to speak first, and it's not to be interpreted as an advantage point or anything of that kind. It's simply a traditional procedure that the person who brings the dispute is the one who speaks first, and then you will have an opportunity to follow that and state the case from your point of view. John, as I explained, you would be the first to give your side of this dispute. So would you start out and give us an overall sense of it, and we'll get back to any details as we go along.
All right. 3 years ago, Marie and I signed a contract whereby she would sell my work, and she hasn't done that. I gave away 20% of my profits. She's lost clients that I had before. She hasn't gotten me any new clients of any significance.
Oh, that's
And
a total lie.
Marie, remember the ground rules are that we're not to interrupt each other. You'll have every opportunity to respond to anything that John says. If you think what he says is in error, you'll be able to correct that. So would you hold off?
She's threatened to sue me, which is why we're here.
Are there any questions you want to ask John?
No, I just want to kind of summarize here and make sure that I understand. You're saying about 3 years ago was when you and Marie entered the contract, that under that you were to pay her 20% of the profits. And that, as far as you're concerned, she hasn't been working to get you new clients.
It's not as far as I haven't gotten any new clients.
So you haven't gotten any new clients.
Right.
And moreover, you've even lost some clients that you had before.
Important clients with magazines.
And so you've stopped paying at this point, and you're getting your own clients, and
Right.
and Marie's threatened to sue, as I understand it.
Right. And also, those clients that I have been working for during the 3-year period, I have gotten some clients, nothing of great significance, but in any event, I have no access to the information. She won't tell me who I'm working for.
Marie, would you like to give us your side of this controversy?
It's just typical distortions of job. The reason he's alive today is because he's been eating off of the money earned from the jobs that I set up for him.
Wait a minute.
You 3 years, and
John.
you have been working for 3 years.
Marie, address your remarks to me and
I've been
John.
working really well before the 3 years.
John, we won't be able to proceed as effectively as we need to proceed if you interrupt.
By reminding the parties of the ground rules, the mediators are controlling and directing the process. They ensure that both parties will be allowed to have their perceptions and responses heard.
Want to continue?
When John came to me and asked for a job, he was getting contracts. It was rare for him to get a job that was over $500 to $750. He came to me because I could hook him up with magazine and commercial contracts significantly larger. We signed a contract where I was to get 20% of the gross after expenses and some of my expenses. At times I have to take clients to lunch and so forth. I put together a portfolio. I made a lot of lead contacts, some of which are only now just paying off, but that's how the business works. You don't make a contact and 3 months later you have a job. And there are other contacts that he wants a list of. I simply want to be paid a reasonable amount for the work that I've already done and for those contracts which are paying off for him that I opened up, the doors that I opened to his career. That's all. Now, I was taking this to suit, and a staff person called me and convinced me to come here.
Okay, so you've said, Marie, that you feel that you opened up new doors in John's career.
After each opening statement, the mediators clarify the issues presented. They encourage communication between the partners so they can work through anger and frustration and get to the issues at hand.
What were you expecting to get versus what you think you're getting?
Well, I would expect to be able to pay my rent, to living expenses, and I'm just not getting enough.
And that's because, as I understand it, you think you're not getting the jobs you should be getting.
Marie has a lot of clients, and a lot of artist clients. And I think she's spending a lot of time with them developing those ends. And she hasn't put enough time into my work.
How long have you had the contract between you?
3 years.
3 years. What was the situation at the beginning of your contract? Now, evidently you've been working together for quite a while, so it must have been that it was a satisfactory relationship for some of that time, perhaps most of that time.
The mediators help put the relationship in context by looking at its history. Every contract starts off with good intentions. Bringing up positive aspects of the early stages will help distance the parties from their current negative feelings.
I came to Marie, she helped me with a portfolio, and I've gotten much better. I've got a reputation, and I think I can do much better. And I'm not complaining about, I mean, I would be happy to give Marie 20%, the agreed amount.
So the fee is, the
No,
percentage
no,
is not in question.
it's the amount of clients that I should be getting and that I'm not getting.
My job is to get him contracts. His job is to do the work. My job is not to coddle him.
For God's sakes, don't coddle me. Get me clients.
I get you clients.
Now, hold on just a minute. Now, I can see that you're, both annoyed with each other at this point, but it seems to me that, there's some very important communications going on here that you're beginning to hear, and maybe you should hear a little more explicitly. Would you, John, tell me what Marie has been saying in relation to the other clients? Because you complained that she's spending more time with her other clients, not giving enough time to your account, and therefore you're ending up with less income. Now, could you tell me, just for my understanding,
I'm not sitting in her office, but whenever I call, whenever I come by, it's John, I don't have time. John, I've got to work.
That's not yeah, I understand that, but the question I'm asking is, what was her response to that?
I'll get you clients as the time comes. I mean, as they come in, you're getting your share.
Yes.
So it sounds like
Is that
Go
a
hang
fair
out.
rendition of what you said, or would you want to
I
add to
say
that?
two things. One, I say I'm getting you work as close as I can, and the other thing I say is if you would like to talk with me, make an appointment.
Our agreement doesn't have anything about appointments. It doesn't have anything about calling at certain times. It has stuff about the amount of money you receive and the amount of work you're supposed to get me. If you don't want me to come in, that's fine. Give me clients. I'll stay home and work.
Do you have any objection to making an appointment?
No, I'll make an appointment.
An important purpose of the mediation process is to create a safe place for parties to vent their emotions while they identify their concerns. Here, John has expressed his anger and reached an agreement in principle about making an appointment with Marie. Now the mediators steer the discussion into an apparent main issue, John's request for the list of business contacts that Marie generated.
Let me ask you this. Is this typical in the industry that John would not be receiving a list of the contacts which you've made?
Yes, it's typical. If artists go making all of their own contacts, then I have no work. Normally, I hold on to the contacts. I also nurture those contacts. He doesn't want to deal with them. They're difficult to deal with.
If Marie doesn't want me in her office interrupting her lunch schedule, then all she has to do is give me that list of names, stop threatening to sue me, and let me go on my merry way, and I will be quite happy.
Okay, let's spend a little time on the list of names. Marie, do you want to, enlarge a bit on why you feel that, let John know why you feel that giving up the list of names is not part of your contract?
My contract is to be paid 20%. I am owed $2,000. Now, there are people for whom he has already worked, which were I paid, I would certainly be willing to give up those names. However, those contacts that I have made that there has been no work yet, those contacts, I have other clients, and if he doesn't choose to be with me, I see no reason to nurture that. Then I would simply say to those, well, this gentleman is no longer with me that I was considering. However, I do have some other graphic agents, artists that work with me. But for those who he has already, and who it's clear that they enjoy his work, and they, then I'm open to discussing those.
Summarize what you've said. The first condition is that you would like to be paid the $2,000 that is owed to you.
Yes.
Under that circumstance, you'd be prepared to give John a list of clients, of those clients that have paid for his work before, that have, in effect, hired him on, but not those that are just prospects.
I'll give her the $2,000 when I get the list of names. This is the problem. And I have no way of knowing this, but I've dealt with Marie for a long time, and I know how she works. And she has a little list of graphic artists that are signed up under her, and she picks her favorite, and that's where the work goes.
I pick clients based on the kind of work they do. I know what your style of work is, where your strengths are, and where your weaknesses are. And that's how you get your clients, based on who you are. based on what your work is. I don't have a list with the top. I don't play favorites. That's your paranoid artist fantasy.
By now, it's obvious that the list is not the key issue in this disagreement. Instead, poor communication and the quality of interaction between the parties have emerged as sources of conflict. The mediators deal directly with these problems by discussing the degree of contact between John and Marie and the types of work Marie refers to John.
But I heard you say that you'd be amenable to setting up appointments.
Sure.
Yeah.
How frequently would you say would be a reasonable time or period for such meetings? If you'd like to meet once a week?
Yeah, I would. I'd like a report once a week. I'd like to know what's happening. And maybe a meeting bi-monthly.
Bi-monthly.
Sure.
How does that sound to you, Marie?
Well, you know, John, I don't think that you have as good an understanding of the kind of work I do as I think I have of the kind of work you do. It's not like every week there's an intense amount of work. One week I may work 30, 40 hours just on you. Another week I might get 2 phone calls. And yet to have to report into you every time, I think that that's a level of distrust. Now, I admit that I have not been, before you terminated the contract, the office certainly could have been better about keeping contact with you. All right. But a weekly is out of the question. I think that certainly a written report every month, and then if every 6 weeks you want to sit down.
Would it be possible to make up some arrangement as an interim thing, just to start out, because you've said, you've lost some trust, and then see where you go from there?
Well, I suppose what I'm saying to you is that I need more work. And maybe we haven't, there's been a problem in communication here, but I need more work. If that means that I have to work with more photographers, then I will. And if that means that I have to work faster, then I'll work faster. And if that means doing small pieces, then I want to do small pieces.
Well, I think if you're prepared to do the 2- and 3-day turnover jobs that you'd said before, that you thought that was simply unreasonable for someone to ask that, I certainly could direct some of those to you.
It's not...
You had told me before, you said go back to them and tell them that they can't expect this quality of work in those days. And I said, well, this is their deadline.
It's not always just it's one thing to be asked to do a week's project in 2 or 3 days. It's another thing to do a 2 or 3 day project in 2 or 3 days. I can do that.
I can only work with the deadlines they gave me.
I will do a 2 or 3 day project in 2 or 3 days. I might even do a 3-day project in 2 days. I'm talking about the small projects, which I'm not getting, which would supplement the big projects.
I'll give you your number and you negotiate the contract, but if I do that, I think I should get a percentage of it because that will be a contact that comes through me.
For acting as a clearinghouse, you're an agent.
Yes,
So
I think it is not unreasonable to ask for a
So what sort of
percentage.
reduced rate?
I think 10% would be fair. I don't want to quibble about it back and
For
forth.
giving them a phone number?
For
See, this
giving
is
them
why I
a
can't deal with
recommendation
this
and a referral.
With the mediator's assistance, all issues are now on the table. Trust, the amount of work, selection of work, contacts, meetings, and communication. They've helped diffuse the intense emotional responses to these issues and have aired misunderstandings and presumptions. Any blocks to reaching agreement can now be explored.
I said that those jobs that you had previously said that you couldn't speed up, you've now said you would. I said then I would turn those contracts over to you. I would offer them to you again. On the small contracts I had been turning down, I said we would have to negotiate a percentage, but that I would serve as a recommending and referral agency for you. So it's not simply a referral, but they'll get one name, yours.
Marie, I just want to comment here on the process a little bit. I noticed that we start to move toward resolution, and there have been some proposals on the table for how to resolve that. And every time we do that, I'm experiencing that you back away from that your voice level goes up, and you aren't prepared to be specific as to how things are going to change when John's requested that from you. And I'm wondering if, number one, if that's consistent with your having said that you would like to continue to be his agent, and number two, if that's consistent with getting a resolution today and how we want to work together.
I feel that I have not heard from John any indication of any kind of respect for the work that I have done with him over the last few years. And I'm quite willing to continue the relationship, and I think it would be positive. However, I think there needs to be some acknowledgement that it is not simply because of the quality of your work, John, that you are doing better.
Okay. Is that something that you feel prepared to acknowledge?
Okay, well, I hear that. I mean, I know that she has gotten me some good accounts and she has helped build my reputation. I'm doing better work.
You're looking at Marie. Why don't you say you and see how that goes over?
You've done good work. I mean, I've gotten better clients.
Thank you.
I'd like to continue.
Well, we can probably work something out. I mean, you're right, there are contracts that I could have sent you these rush jobs, you know, and certainly I can ask you first if you want them and give you the option to turn them down. Would that make you more comfortable?
I'd like to just switch gears here a minute and ask that you each take a minute, and it might even be helpful to write some things down, and fantasize what your ideal working relationship would look like from this day forward if you were to continue working with each other, because you've each expressed an interest now in doing that.
Mediators are trained in techniques that move the parties towards resolution. These mediators have chosen to broaden perspectives through a fantasy agreement. Sometimes they meet or caucus separately with each disputant to clarify their needs and any blocks to reaching agreement. Now, after reviewing the fantasy agreements, the mediators assist the parties in clarifying resolutions to their issues and creating a new agreement, one that embodies workable resolutions to their problems.
What about a time factor in terms of some of these new understandings? What about the possibility of, let's say, trying it for a 3-month period or a 6-month period, whichever would be convenient and realistic? Is that
sounds good to me.
Something that you could consider?
Good.
Well, I think it would have to be a 2-tiered time period. Frankly, I think that certainly 6 months would be enough to see if the new, particularly if we're only meeting every 6 weeks, then 3 months is not sufficient because that only is 2 meetings. But I think that the one thing that has to be acknowledged and recognized is that since I am going to be working on the account and there will be reports of the contacts that I've made during that 6 months, that I should get some percentage from the work that comes up, say 6 months after the termination, from contacts that I've made.
So we're talking about 6 months as a trial continuation, and if there's a termination, then there would be another 6-month period during which you would be entitled to the fees of those clients that you've been working with during that 6-month period.
That bear fruit from the
That bear
6
fruit
months.
within 6 months later.
I mean, I agree in general as well.
With the mediator's assistance, participants finalize a new agreement that spells out the details of each issue to everyone's satisfaction. This new agreement is then reviewed, typed, and presented for signature.
I'm really glad that we're going to be able to continue working together, and I really didn't think this was going to work. I was ready to sue. I really appreciate the time that you two took helping us sort this out. Thank you.
I want to congratulate both of you for deciding to use a mediation process to solve your differences. I think you've worked very hard at it and you've done very well. Thank you very much.
Thank you.
Thank you.
It's really thanks to your hard work that you put
That's
it
right.
together.
That's
Congratulations.
Congratulations.
The success of mediation often exceeds the parties' expectations. By using this process, many people learn how to negotiate successfully.
I think this program has been an important resource for the arts community. I think we're part of the hidden infrastructure, which is able to help organizations stay put together, stay out of long, drawn-out court battles. Even to take somebody to small claims court can be a very traumatic experience. People don't speak to each other after they go to court. But most of the time, after they leave mediation, even if they don't work it out completely, they've learned something about the other party, and they've learned something about how to articulate their needs earlier, maybe clearer, so that they don't get into the same kind of trouble the next time.
Through all its programs, California Lawyers for the Arts helps artists avoid legal problems. But when disagreements arise, mediation is an excellent method of resolving disputes and creating new avenues of agreement.